Granite State asked me to review this news article. Federal judge rules Massachusetts law prohibiting secret audio recording of police, government officials is unconstitutional. And so I shall. This is it. And I don't like reviewing news articles because they don't tell you what the judge said. They tell you what someone's impression of what the judge said is. So this is the article. It will be linked. You can review it as you will. It involves Project Veritas and Jamaica Plains people, and I found it on the Project Veritas site. This is it. And it's a 44-page it's a 44-page decision. It's a 44-page decision. So again, this will be linked as well. I am not trying to snow anybody. I just prefer to work off the actual court document. So what is this? Oh, yeah, it references Garricky, and that was a new one. That was fun to read. Anyway, doesn't really matter. It's referring to this particular law, which I thought I went over at some point in time. Interception of oral and wire communications, but I may not have. Boop, 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 boop. Maybe I went over it when talking about two-party consent things. I don't know. I get lost in all the things that I've done. But the point is that it doesn't really change anything. On the core constitutional issue, this is the First Amendment issue, the court holds that secret audio recordings of government officials, including law enforcement officials performing their duties in public, is protected by the First Amendment, subject only to reasonable time, place, and manner restrictions. Because Section 99 fails intermediate scrutiny when applied to such conduct, it is unconstitutional in those circumstances. I wish that, I mean, it's 44 pages long, and I wish the court had done a little more with it. Two interesting things. This is a district court, so don't get too excited. It isn't a court of appeals, and it obviously isn't the Supreme Court. It's a well thought out decision, and the court did the right thing, but the court punted on questions that I would have liked to see answered. Interesting thing is the court did decide to analyze it under a conduct restriction. That's the O'Brien kind of burning the draft card restriction. So it's intermediate scrutiny. It's always weird to me which way they're going to slice it. This court decided to slice it as a conduct restriction. But there's still the reasonable time, place, and manner restriction. They decided to punt on that. So some difficult questions remain about what constitutes a public space and who is considered a government official for purposes of the right to record. The facts of Glick provide some guidance on the public space issue. There, the recording took place on the Boston Common, the apotheosis of a public forum, in which the rights of the state to limit the exercise of First Amendment activity are sharply circumscribed. Many of the police-involved scenarios that the plaintiffs desire to secretly record would occur in similar locations, traditional public forums like parks, streets, and sidewalks. It seems clear enough from Glick and Garricky, he was recording a traffic stop, I believe, that the right to record a government official, including law enforcement official, performing her duties generally applies in public forums. But the holding of Glick uses the phrase public space, not public forum. The plaintiffs in Martin believe that the right to secretly record the police extends to private property that is open to the general public, such as a restaurant. For example, one of Martin's recordings of police activity occurred at the Arizona Barbecue restaurant from a vantage point on the sidewalk outside the restaurant. In general, though, the First Amendment does not guarantee a right to free expression on private property. Moreover, there is a definitional issue with Glick's use of the term government official. Glick, Garricky, and cases cited therein teach that a police officer falls within the ambit of government official. But who are these other government officials? The First Amendment doctrine surrounding public officials may provide some guidance. The parties do not focus on defining public space or government official, and it is not prudential under the ripeness doctrine to do so now. While Glick's use of the term public space seems to indicate something broader than public forum, and its use of the term government official includes a broader scope of public official than law enforcement officer, the court leaves it to a subsequent case or to subsequent cases to define these terms on a better record. So it is saying everything that we know already is certain. We already knew that the government could use reasonable time, place, and manner restrictions to prohibit recording. We already knew that. Even in public, they can do it. So it doesn't change anything. We knew it was intermediate scrutiny. This court decided to go with a conduct analysis approach, which I have stated previously was a potential. So that doesn't change anything. I still think that it will come down to a forum analysis depending on the facts at a minimum. And the court punted on the definition of what a public space is and whether or not public space goes beyond public forum into private property that's open to the public. So I wish it was more clear. I really do. I would love a I would love a clear definition. I would love the Supreme Court to get their teeth into it to figure out what the various appellate courts have meant. They all have the same basic language, that you have a right to record the police in public subject to reasonable time, place, and manner restrictions. They all basically hold the same thing. It would be great to have clarification on where the boundaries are. We don't have it yet. I am waiting for someone to get arrested doing it. And granted, you know, if you believe that you're right and that you have a right to record in the DMV, she started this off by saying that, asking if I'd seen her pass audits. I assumed that she had meant subsequent to the videos that I did on her. I don't think it's as strong of an argument as she wants to believe. She defines a pass as being allowed to film. You could say then that there is no speed limit if you have ever driven past a cop while speeding and not have been pulled over by the officer. It's the same logic, and it doesn't make sense. So congratulations on enjoying sunny California, Granite State. I don't know if gingers can get tans, but maybe you should work on it while you're here. And I have given you, out of the goodness of my heart, the analysis that you were asking for. Thanks for watching, and have a great evening.